All right. Good afternoon, everyone. I hope you're all doing well. My name is Connor Hannigan, and I'm a legal fellow here at the Cancer Legal Resource Center. We're going to be going over 5 legal tips for caregivers today. I wanted to let you all know that if you have any questions, you can type them in the box on the control panel. We'll try to get to those after the presentation. Hopefully we won't take up the full time, and we'll have time for questions. Otherwise, if you do have questions that don't get answered, you can always visit our website or give us a call. We're a free legal resource service that I'll talk about in a few minutes. So we'll make sure that we get your questions answered. So like I mentioned, I'm a legal fellow here at the CLRC. I'm also a caregiver myself, and so hopefully I can provide some insight into that respect here today as we go over some of the different legal tips that exist. We're going to be putting this webinar up on our website along with some of the previous webinars that we've done. Hopefully that will be up by the end of the week. All right, so I just wanted to briefly talk about my organization, the Cancer Legal Resource Center. So what we do is we provide information and resources on cancer-related legal issues, and we provide them to patients, survivors, employers, healthcare professionals, and anyone else that's affected by cancer in some way. What we try to do is provide those resources following the educational model. We give people information so they can correct decisions for them. We provide resources in English, Spanish, and French, and all of our services are confidential, of course. We don't provide legal advice, so while we do provide education and give direct legal advice, we can give information and resources that will hopefully allow people to make those decisions. We operate a national telephone assistance line, which I mentioned a few minutes ago, and that's our phone number up there. You can either fill out an online intake form at clrcintake.org. That's usually much faster. What we'll do is we'll research your legal issue that you give us, and then we'll give you a call back with different information and resources that we've come up with. You can also feel free to give us a call, but sometimes that results in some phone tag, so I think usually we direct people to that online intake form. So what are some cancer-related legal issues? I think everyone that's listening to this broadcast probably has a good idea about some of these, but some of them include health insurance, employment law, disability insurance, life insurance, government benefits. We also help people with financial resources and different things related to that. So we run the gambit of different topics that we cover and that people with cancer frequently face. We're going to touch on a few of these, of course, in the presentation today. So I think it's important to start out with this slide right here that is just a reminder that we're going to talk about federal and some state laws, and these are really just a baseline of some of the rights that are afforded to cancer patients and caregivers. So keep that in mind. Just because we mentioned that a different law applies to a certain number, a certain size of employer, doesn't necessarily mean that there isn't something out there where you're located that might provide some additional protections as well. So you might be entitled to more protections, and it's important to do a little research for yourself or get in touch with us and let us know where you are, and we'll try to either connect you with someone or do a little research to see what those requirements are for you. Also, some other things like employee manuals or any contracts that you have, any insurance plans, those are different types of things that provide additional protections. So the first tip that I wanted to get into is just knowing what your duty is as a caregiver. So there's generally no legal requirement to become a caregiver, and that's regardless of whether the person who is ill is a family member or a close friend. A person can take on responsibility for a patient's health, and that can create a duty of care. So whether a caregiver has taken on a duty of care for another person and the extent of the duty, that's going to depend on each situation. So basically, you don't have to be someone's caregiver, but once you begin to act like their caregiver, you have a duty to do so responsibly. So I wanted to talk a little bit about workplace protections that exist for caregivers, because I think a lot of people are aware that there are workplace protections that exist for survivors, people living with cancer, cancer patients, but there are a few protections that also exist for caregivers. And the first law that I'd like to talk about is the Americans with Disabilities Act, or the ADA. That's a federal anti-discrimination law. Many people with cancer don't consider themselves disabled, but it's important to note that the definition of disability is different in various legal contexts. So often, regardless of how a person chooses to affiliate themselves, it's important to start with the definition of disability to see if a disability law offers protections or benefits to a person living with cancer. As we all know, a person's abilities are constantly changing with a cancer diagnosis, so it might be necessary to reassess a patient and therefore a caregiver's eligibility for programs and laws if the survivor's abilities change. So there are three parts to the ADA's definition of disability, and I think this is usually a good place to start, is looking at the definition of disability to see if it applies to the cancer patient. The first part is that they have an impairment, and the second part is that the impairment limits a major life activity, and the third part is that the limitation is substantial. So what is a major life activity? Major life activities are broad for the purpose of the ADA. They include anything like walking and talking, breathing, eating, caring for yourself, and also the particularly broad activities of daily living. It's important to note that these are very broad examples of different things. They're just examples. There can be many other different important parts of daily life, but if one of these is affected by a cancer diagnosis, then that person, and therefore potentially that caregiver, might be eligible for protections under the Americans with Disabilities Act. So what is a substantial limitation of the major life activity? The substantial limitation is an inability to perform a major life activity in the way that a person in society would usually be able to perform it. So cancer can be a disability. I think the important takeaway is that cancer can be a disability under the Americans with Disabilities Act, but it's determined on a case-by-case basis. So it's also not just the cancer illness itself that's considered, but also the side effects of treatment. So perhaps someone's cancer is not causing them to miss out on being able to breathe or eat or get around or do activities of major life activities, but perhaps their chemotherapy has really been particularly difficult, and that's keeping them from being able to do those things in the way that they would usually be able to do them. So therefore, they could probably be eligible for the Americans with Disabilities Act. So I think it's important to note that the Americans with Disabilities Act does not apply to every employer. It applies to private employers with 15 or more employees and state and local government employers. It also prohibits the employers from excluding or denying equal jobs or benefits because of an individual's relationship or an association with an individual who has a disability. And so that includes caregivers, and that's what we'll talk about in just a minute. So it also doesn't apply to, the Americans with Disabilities Act obviously doesn't apply to every single employee. You have to have a disability, which we just talked about, and the person must be qualified, which means that they can perform the essential functions of the job with or without accommodations. So if a person can't perform their job, they're not necessarily going to be protected from decisions by their employer. So I think also it's important to check state laws for extensions to smaller private employers, because various states will have a similarly written law, such as the Americans with Disabilities Act, but it'll apply to employers with 5 employees or 2 employees. So, like I mentioned before, the ADA prohibits qualified employers from excluding or denying equal jobs or benefits because of an individual's relationship or association with an individual who has a disability. So caregivers should therefore not be treated differently or have their employment terminated by an employer based on knowledge that the caregiver has an association with a person with a disability. So I think although it's important to note that caregivers are protected against job discrimination due to their associations with a person with cancer, they're not entitled to reasonable accommodations, such as a reduction of work hours or a modification of the workplace. And that's unlike a person with a disability who's protected under the Americans with Disabilities Act, who may be eligible for reasonable accommodations. So that means that if an employee's or caregiver's work performance drops due to their caregiving responsibilities, employers can make employment decisions based on that performance to potentially terminate their employment. But if the employee is performing their job adequately and the employer learns about their caregiving responsibilities and then starts to treat them differently, then they may be discriminating under the Americans with Disabilities Act. So now I want to talk about taking time off to care for a loved one. The Family Medical Leave Act, or FMLA, allows qualified employees to take up to 12 weeks of unpaid leave, and that can be either all at once or in shorter blocks, and we'll talk about that in a little bit, within a 12-month period. So this law applies to both patients and caregivers of a covered family member, and we'll talk about that in a minute. They have to have a serious health condition, and a lot of times cancer can qualify as a serious health condition under FMLA. To be eligible, employers have to have at least 50 employees within a 75-mile radius in order for their employees to qualify for FMLA leave. So say you work for a big statewide employer or big federal employer that has a few pockets of employees of 10 people at each job site, they likely will not qualify for FMLA leave. But if you work for an employer who 60 employees based in two different locations that are only 50 miles apart, then they would qualify for you would qualify for FMLA leave. It's also important to note that you have to meet a work requirement. So employees have to have worked at least 1,250 hours in the past 12 months, and they have to have worked for the employer for at least a total of 12 months in the last 7 years. So you have to have at least worked for a certain period of time, even within the past 12 months, in order to be eligible for FMLA leave. So medical certification from a health care professional is often required, stating that the caregiver services are needed. So, like we mentioned before, a person's allowed to take FMLA time off to care for either themselves, the person with a serious health condition, or for a covered family member. And people that qualify as a covered family member are either parents or a person acting as a parent, minor children, including biological, adopted, and foster children, and spouses. Unfortunately, this law does not extend to taking care of siblings who need assistance, so that's just an unfortunate part of this law. And so we mentioned this work requirement. You have to have at least worked for 12 months and 1,000 or 12 months or more and 1,250 hours in the last year. So I think it's important to note that we mentioned not all employers are covered by this federal law. So government that means either local, state, and federal employees, employers, they're subject to FMLA, and as well as private employers that have 50 more employees within a 75-mile radius. So we mentioned a little bit about medical certification. Employers have to comply with all applicable laws regarding the confidentiality of medical information. So an employer must keep an employee's medical information and their medical records separate from their personnel files in order to protect their privacy. I think a good tip is that you can ask to have a general practitioner, the person that you're caregiving for. If you don't want to disclose that they have cancer, you can have their general practitioner fill out this form, or someone other than their oncologist, so that the employer understands that it's a serious medical condition, serious health condition, but they don't necessarily know what type of medical condition it is. We have a helpful handout on this, as well as everything else that we've talked about. We have more information about them, so that you're always free to contact us, and we'd be happy to send it out to you. So I think another thing to note is that the 12 weeks of leave time that you can take under FMLA doesn't have to be taken all at once. It can be taken intermittently, or it can be taken in just a 12-month block. You can use the intermittent leave only when it's medically necessary for the patient to get to appointments or do things that are medically necessary for them. So it's not just necessarily possible to do that for things that aren't medically related. So I think it's also important to note how the FMLA can work alongside the Americans with Disabilities Act. So if you took your 12 weeks of FMLA leave and that was exhausted, but you still needed additional time to take care of the patient, you can request for an accommodation to extend that leave. Usually that's more likely to do that when you have a definite end. You know that you'll have to be caregiving for another week or so, but that's not always the case. If you don't have a definite end, because a lot of times we're not sure with cancer treatments when exactly that's going to be the case, you don't have to give a definite end, but it's usually more likely that an employer would grant that. Employers don't have to grant these requests. Unfortunately, it's just something that you can ask for to try to get an extension of leave. So I wanted to talk a little bit about paid family leave, and I think that's an important distinction that I think I just briefly mentioned when we were talking about FMLA leave, is that with FMLA, that is the 12 weeks of unpaid family leave. So unfortunately, unless there are some vacation days or there's some other way that you can get paid out for sick days or something like that, or you have an employee policy, that FMLA time is not going to be paid. But there are only a few states, unfortunately, that do have paid family leave laws in effect, like California, New York, New Jersey, and Rhode Island. So it's important to check with your local government agency to see what sort of options that they have in your state. And look to see if there are some sort of partial wage replacement. I think the other thing to note with paid family leave is that you don't necessarily get 100% of your income during that time period. A lot of times it's cut down to 75 or 55% of the income that you're receiving during that time period. So I just wanted to get onto our third tip right now. I think it's really important to have difficult conversations early, and it's also important to make sure that you document these conversations, that your loved ones document their wishes, so that it's very clear about what they want in terms of end-of-life care. So that's important just both in the sense that you want to have the best chance of creating valid legal documents, and it's important just so that you reduce sort of the all-around stress, I think, as a caregiver, the unknown about what someone might want. If you have these conversations, you know exactly what the person wants and what they need, and it's much easier to make these decisions. I think also important to note is that, unfortunately, the longer that someone waits while an illness progresses, the greater the likelihood that some of these documents might be called into question. People have to have the mental capacity to create these documents for them to be valid. And if you have an illness that might make you more groggy, or the drugs might make you more groggy that you have to take to combat the illness, then it might cause some of the validity of some of these documents might cause them to be called into question. It's also important to make sure that you allow the patient to make their own decisions. I think it's important to have these discussions, but if a caregiver is pressuring a patient to make healthcare and financial decisions, then these documents can also be called into question for fear of undue influence pressuring the person to make that decision that they actually didn't wish to make. Make sure that all your documents, if you already have these, make sure that they're up to date and that they follow current state laws, because things can change, assets can change. The people that you might want to name as beneficiaries or people that are going to be controlling healthcare decisions, those might change as well. So first off, I wanted to talk about advanced healthcare directives. Those are written instructions that state a person's wishes about the medical care and treatment that they want to receive if they're unable to make medical decisions for themselves. They vary greatly by state. Some of them have 4 parts, such as a power of attorney for healthcare, instructions for healthcare, organ donation instructions, and physician information instructions. They're designed so that they avoid any unwanted care that the patient has, they reduce the patient's suffering, and they ensure that a person's wishes are honored at the end of their life. I think another important directive is a hospital visitation directive, and that states the people who the patient may or may not wish to have them visit them in the hospital, and that sometimes can be included with a durable power of attorney for healthcare or in a separate document. And I think all of these documents are, while these are difficult things to talk about, they are very helpful if you do get to this point, so that as the caregiver, you don't need to be getting into arguments with family members or anything like that. It's all very clear as to what the person you're caregiving for wants exactly, and there's no discussion about it. Also, you get the hospital to back you up on everything that you're saying that the person wanted, because you have gone through the steps to make sure that that's the case. So you can spend your time caring for the person that needs it rather than dealing with any of the other things that are going on. I had a friend who was at this point in her life, and the family was trying to decide between having her take more medications and be less aware of what was going on, or doing less medications, being in more pain, and being more aware of what was going on. And there was a lot of debate between the family, but fortunately she had an advanced healthcare directive that said she wanted to be in less pain, so that took all of the family drama out of it, making sure that she was comfortable and that she could actually just spend her time with her family about the more important things that were going on at that time. So power of attorney for healthcare, this can the name of this can change based on what your state calls it. That names someone who is either a relative, a friend, or someone else that you trust to make medical decisions when the patient is unable to do so. The power of attorney deals with all medical decisions unless the person decides to limit it. So you can have it be as broad as you want it to be, or as specific as you want it to be. You can even name the specific instructions and specific treatments that someone wants, so that they can be very clear about this. I think it's important for the patient to really consider who they want to name as their power of attorney for healthcare. It may be their primary caregiver, it may not. It should definitely be someone who's trustworthy, hopefully someone who shares the same values, and someone that the patient has talked about their end-of-life wishes with. So I think one thing that I've mentioned in some of my presentations is that if advanced directives and all of this estate planning information seems a little overwhelming, I would suggest getting something called the 5 Wishes, which costs $5, but you can order it online and they'll mail it to you, and it is something that, as a caregiver, I think is really helpful to fill out along with the person that you're caring for. It gives you an idea about what questions are helpful to ask, and some insight into which questions are harder than others to answer. So while it's always best to ensure that you have an attorney look over any legal documents, that's not necessarily possible for everyone. The 5 wishes meets the legal requirements for an advance directive in 42 states and DC. In the other 8 states, your completed 5 wishes can be attached to your state's required form. I think it talks about different things about how comfortable you want to be, or how you want to be treated, making sure. I think it just thinks about a lot of questions that you wouldn't necessarily think about unless you'd been through this before. So I just want to talk briefly about power of attorney for financial affairs. That allows a patient to appoint someone else to handle their financial matters, such as paying bills or managing bank accounts. A power of attorney for financial affairs is a legally binding document that a person prepares or has prepared for them to sign, where they choose a trusted person who then becomes known as their agent to act for them if they become incapacitated. So the 2 most common types of power of attorney for financial affairs are durable power of attorneys and springing power of attorneys. If a person wants an agent to start making decisions for them right away, and for that agent to continue making decisions for them when they become incapacitated, they would create a durable power of attorney. That starts now and stays in effect until they become incapacitated. If someone wants an agent to act only when they're unable to make their own decisions, when they're found to be incapacitated, then they would create something called a springing power of attorney, and that's more of the more popular version. Whether someone's incapacitated is determined by a judge or a doctor, and that person doesn't get to start making decisions for them in the springing context until they're determined to be incapacitated. Both of those end when someone passes away, so that then you would move on to wills and trust documents. Another thing that I think is important for caregivers is medical records access. So the privacy rule, which is a federal law under HIPAA, gives individuals rights over protected health information and sets rules and limits on who can look at and receive health information. Therefore, written permission is needed for a caregiver who's not a parent or guardian to access medical records. So I think in a lot of situations, either after someone's passed away or when they're trying to get treatment, but perhaps they've become somewhat incapacitated, a caregiver is trying to manage all of this for them, and they're not able to access these medical records because of the privacy rule, and the patient has not given written permission for the caregiver to access any of that information. So if you think that's something that's going to be important for the patient that you're helping, then I would suggest getting written permission and giving that to the medical professionals that you're working with as soon as possible, so that you can make sure that you can access some of those records if they're needed. So then the 4th tip that I want to talk about is just understanding liability for medical debt and to research eligibility for any entitlements that may exist. So I wanted to talk a little bit about Social Security survivors benefits. Those are payments made by Social Security to family members of people eligible for Social Security benefits but who have passed away. So to be eligible for Social Security retirement benefits, a person must have worked and paid into Social Security benefits. A lot of jobs, such as teachers, have separate retirement and disability funds that may take the place of Social Security, so it's important to make sure that the person has actually paid Social Security taxes, and that's the first place to start to try to access those benefits. The number of years of work needed for a family to be eligible for Social Security depends on the age of the person when they pass away. So the younger the person, the fewer the years they need to have worked. But no one needs to have more than 10 years of work to be eligible. However, the benefits can be paid to the worker's children and the surviving spouse who's caring for the children, even if the worker doesn't have the required number of credits. The worker would need to have worked for at least one and a half years in the last 3 years before their death in order for their children to access their spouse taking care of the children to access those benefits anyway. So you can see on the slide, it talks about who the eligible family members that are included: widows and widowers, including divorced couples if the marriage lasted at least 10 years. Some children up to age 19, or if the child became disabled before age 22, and some dependent parents. The amount of money that a survivor might receive in these situations would vary based on each of these relationships. So just a few other things to know is that there are limits on how much survivors can earn while they receive benefits. So if someone is making money and trying to also receive Social Security's survivors benefits, they may not actually be eligible to receive that money. And also benefits for a widow or a widower may be affected if they remarry before age 60, or if they're disabled before age 50. And also, I think it's important to look and see if the widow or widower is personally eligible for the retirement benefits. Something else for caregivers who have different types of relationships with the patient that they are caring for. So when someone dies, their estate is responsible for paying off their debt. If the estate goes through probate to establish the legal validity of a will, a designated administrator or executor will look at assets and debts guided by law to determine in what order bills should be paid. There are a few situations in which someone else may be responsible for medical debt should a person pass away. So one of those situations is if someone shares a joint account with a family member or a business partner, then creditors may be able to access that account to cover a balance on a debt. In another format, under the doctrine of necessaries, a husband or wife could be responsible for the purchase of essential goods and services, including any food, clothing, shelter, and medical and legal expenses. A spouse could be liable for the other spouse's debts and contracts, regardless of their consent or knowledge of the purchase. Creditors could therefore sue either spouse to recover debts on necessary goods and services, but generally debts incurred before marriage by a spouse do not become the responsibility of the other spouse. I think finally, some states have laws that make spouses liable for all debts incurred during the marriage, and many of those states are called community property states, and that's where certain assets and debts are shared equally in marriage. Other states that aren't community property states have similar laws that may require sharing of these medical debts. So it's important to speak with an attorney in your state just so that you understand some of these requirements, and we can give you some information and referrals for more specific information. So the last legal tip that I kind of wanted to cover is twofold, and that's using research skills to either find professional assistance or make things more manageable. So in terms of state programs that exist, and this is sort of enlisting more caregivers to help you with the jobs that you're doing. So there are state programs that exist. Many state or local health departments have licensed home care agencies, and these services can include visits by nurses or social workers, medicine delivery, and help with daily tasks. Clients have to pay for some of these services. Oftentimes, they can either pay privately or through their private insurance coverage. And these agencies might also contract to provide services to patients on Medicare and Medicaid, so that may reduce any cost that the state programs have. Obviously, you'd have to check with your particular state, and we're happy to give information out on that to try to find these home healthcare agencies. Another option is private long-term care insurance. Private long-term care insurance may cover some home care. You can ask an insurance agent to explain the benefits and conditions, or read over your loved one's policies if you already have that policy, to know whether or not they have coverage. Another one is consumer-directed programs. Some states have consumer or patient-directed programs which pay a family member or a friend in certain circumstances. There are strict rules and long waiting lists that usually apply, but that's not to say that people don't sometimes have success in getting paid for some of these services. So what you can do in that situation is contact your local Medicaid office or the National Resource Center for Participant-Directed Services, and the phone number is on the slide, but it's 617-552-6582. Another option is hiring a private professional or a friend. So formal care contracts can set up a payment arrangement between a patient and a caregiver. I think if anyone goes down this route, it's really important to consult a lawyer if possible to make sure that the contract meets any tax, requirements and Medicaid requirements if necessary, and that it's also approved by all of the interested parties to the contract. You can check to see if your household insurance, either renter's insurance or homeowner's insurance, covers any household employees in case an accident would unfortunately happen, but that's something that you do want to consider. I think if someone is hiring a friend to be their caregiver, it's really important to consider the potentially serious emotional pitfalls that can happen when this relationship change in this manner. But I think oftentimes these can be good options for people. And then the second part of the last legal tip is just using resources to make things more manageable. These are some of our favorite caregiving resources that I just wanted to put up on a slide for people to take a look at. We're getting close to the end of our presentation, so I'm going to come back to this slide in just a second. We put on these workshops for free, and so if you found it helpful, it'd be great if you could support our organization, but I understand that many of us are in pretty difficult situations. So if you have anyone else that you know of that donates to organizations, we would certainly appreciate it. And we'll talk about some questions. So I'm going to go and put up those resources again in case anyone wants to write those down while we're taking questions. You can feel free to fill out the question box in case you have any questions, and I'll do my best to answer them. Looks like we finished ahead of schedule, so we'll stay around for a few minutes and try to answer those. And let me go back to any of the resources here in case some of those are helpful, and please feel free to contact us if anything else comes up. We'd be happy to try to help out, and thank you for spending some time with us today and learning about caregiving resources and laws that help and provide protections for people. Have a great day and good luck with all the responsibility and everything that is going on. Thanks. All right, so it looks like we have a few great questions, so I will answer those. Let's see. The first question that we have is, are slides available to download or print? We don't have slides that are available to download, but we will be posting this webinar on our website along with a couple of the previous webinars, and we're hoping to do that now that this is the last of our series of webinars. We're hoping to do that by the end of this week. So those should be available soon.